On Friday, we started our coverage on the situation in Kudomti, Numa local government in Adamawa State, where in 2015, a Nigerian farmer was attacked by an herder who came into his farm, brought out a knife, a fight ensued, and this Nigerian, Mr. Sunday Jackson, managed to hit back, whereupon the herder died. And then there has been a case since that time, 2015, up until last week when the Supreme Court confirmed that indeed Mr. Sunday Jackson, who is now in his early 30s, is guilty of culpable homicide, which is what we know as murder. Now, to further discuss this, I have two important guests. First of all, from Washington, D.C., I have Mr. Emmanuel Ugebe, a U.S.-based Nigerian lawyer and advocate who actually was in court at the Supreme Court last week when the verdict was delivered. Welcome, Mr. Ugebe, to Inside Sources.
Yes, thank you very much, Laulu.
All right. And here with me in the studio, we have Abuja-based lawyer, Mr. Ibrahim Wali, who will also further explore some of the legal implications with us. Mr. Wali,
thank you so much for having me. Thank you so much.
All right. Now, let's start with Mr. Ogebe. Mr. Ogebe, can you give us a brief of how you got involved and what you had in the Supreme Court last week? And what it is that has happened even while you are back in the U.S., just to open the conversation.
Yes, so in 2021, I heard about the death sentence passed on Sunday Jackson after he had been in detention for 7 years. And so I flew to Yola to visit him in prison. I met with his legal team, met with his family. And, I think one of the saddest things for me was that when I went to the prison and I told him I met his 2 children, he said he had only 1 child. And then I told him, no, your wife gave birth while you were in prison. And for the first time since we arrived, there was a smile on his face, and he said he wanted to know the name of his child. So I called his uncle and asked him the name of the child. So I broke the news to him after 7 years that he had a 7-year-old child. And this is the tragedy of the situation, that this man was abandoned all those years in prison. But for the fact that the media highlighted his case and we went there, he would just have perished without any acknowledgement. Now, the same thing happened on Friday last week when I flew from the U.S. to Nigeria to attend his Supreme Court case. And to our shock, the court simply said, appeal dismissed. And with those 2 words, the life of this, man in his 30s is condemned to death. And so it's a very, very tragic case. It's a case that should alarm every Nigerian citizen, because it says that if the government is unable to protect you from terrorists and you protect yourself from terrorists, the government will kill you, just like the terrorists who wanted to kill you. And we must resist that precedent.
Okay, thank you, Emmanuel. Of course, if under the correct estimation of the law, if the law was broken indeed in a way that is reasonable, I don't think we would all be alarmed. But it's because we believe that, there is sufficient evidence and fact to back the claim that there is self-defense in this matter, which is why I wanted to ask an independent lawyer. On Friday, we brought the lawyer for Mr. Jackson here. And today I wanted to ask Mr. Wali, who is an Abuja-based lawyer, who is independent and who has been looking at this case, to tell us what did you think happened, with your review of this matter, Ibrahim?
Thank you. So after a thorough review of the trial court's decision, that is the High Court of Adamawa State, which was conducted by Justice Fatima, and also the review of the Court of Appeal decision without prejudice to the reasoning behind the Supreme Court's decision.
Right.
Because we know that, at least from the interview you had with the defense counsel,
right,
that there were dissenting decisions, and without prejudice to those dissenting decisions, if there were no dissenting decisions, my opinion would have been a little more absolute about the judiciary generally. But without prejudice to the dissenting opinion, I will have to say from the onset that if you look at both the decision at both courts, that is the lower court and the trial court, you see that it was very, very thin, and the evaluation there leaves much to be desired, frankly. First of all, Sunday Jackson was convicted solely based off of his confessional statement. Now, while it is indeed the law, and they continue to reiterate it, they said it in the trial courts and even in Court of Appeal that it is the law that you can convict someone based off of their confessional statement. It is equally the law that in doing so, you have to ensure that it aligns with the entire facts of the case and all the evidence that is put forth before the case. So if you look at the authorities that the courts relied upon, first of all, let's look at Farmer Kinwa versus the state, for example. Both the trial court and the Court of Appeal relied on this same authority. If you look at the authority, the defendants there was not convicted solely based off of his confessional statement. There were so many other corroborating statements, even though the corroborating evidence, even though the court did mention that you can actually, but it wasn't the case. And in fact, in that case, which was the main case that both courts relied on, at the Court of Appeal, the decision, the trial court gave death. At the Court of Appeal, the decision was commuted to 15 years imprisonment. So from my understanding, if you are going to rely on a case, it is very important to ensure that the case has contextual similarities with the case at hand. For that case, Farmer Kinwa actually had a fight with the deceased earlier on, and it had to do with money, debts, and they were separated. And then the local community leader said they should come for a meeting. Right, so on their way to the meeting, a fight broke out again, and he stabbed him at the back of his head, and then he died. The trial court said that was murder. They went to the Court of Appeal. The Court of Appeal said that, well, because there was no evidence of premeditation, because this fight was sudden, right, it was commuted to 15 years. I think that would have sufficed for Jackson Sunday. But I think what actually happened with Jackson Sunday's case, apart from the judicial review, was that the defense counsel relied too heavily on self-defense. There are other defenses that would have sufficed Jackson Sunday, like the defense of provocation, that is heat of passion, the defense of this, suddenness. But even if a counsel does not raise it, if you look at Wilmington versus DPP, Shala versus the state, it is the duty of the state, or rather the court, to ensure that each and every defense that is applicable for a defendant is considered.
Which didn't happen in this case.
It didn't happen in this case. And if you look at the section 221, 222, 223, and 224 of the Penal Code Act, or the Penal Code Law of Adamawa State, it gives the levels of culpable homicide. It begins by defining what culpable homicide is, and then it goes on to tell you what culpable homicide that is punishable with death, and then it goes on to tell you culpable homicide that is not punishable with death. So for a court to come to a rounded conclusion, it ought to analyze all of it to ensure that the facts do not fall within the exceptions. That didn't happen. In fact, there was really no analysis or evaluation apart from the reiteration of what the concept is. And that is one of my problems with, the way our courts approach decisions. So you go on, you want to rely on a decision. And for example, they relied on the case of Adaje versus the state. In that case, there were about 7 witnesses corroborating the confessional statement. And by the way, it is important to note that confessional statement of Sunday Jackson was actually written by the police officer, even though he claimed to have signed up on it. Yes, to have signed up on it. But we know the police, we know our law enforcement agencies. If you read the way it was couched, you know that this was premeditated on their part to get those elements out there. So the court should have, really cautiously looked at it. But obviously, the defense counsel as well ought to have, either retracted or challenged the voluntariness of the. It's argued that they challenged it, and then they withdrew the challenge. But they withdrew the challenge. At the stage of trial within trial, they withdrew the challenge. However, the Court of Appeal went on to actually say that there was a trial within trial, even though the decision of the trial court shows that there wasn't a trial within trial. But there's something that I call the confessional tyranny of the confessional statements. Now, that a statement is before the court officially, is admitted before the court, does not mean that it is presumed to be credible. Admissibility is simply the stage of ensuring that an evidence is proper before the court. The court has to now go on and evaluate and analyze the evidence to ensure that it is credible before it grounds its decision based on the evidence. Now, the other evidence was merely the postmortem result that was given by the doctor, and it had nothing to do with, maybe the pattern of the stabbing. It only showed that indeed there was a death. Somebody died through stabbings on the neck, but that was it. It had nothing to do with the nature of the stabbings, the number of the stabbings, even though at the appeal court, in fact, at the trial court as well, the judge said that there were 3 stabbings. But from the testimony that we read from the judgment, the postmortem, the doctor only said that there were multiple stabbings. He didn't say that there were 3 stabbings. Now, the court's reasoning, quote unquote, was that because he had already collected the knife from the assailant, and because it was a farm, it means that he had enough time to leave. But there was no evidence whatsoever. And if you look at this Famakinwa state, that the case that they relied on, it was commuted to 15 years simply because there was no evidence of premeditation. That there was no direct evidence that indeed there was premeditation. And by law, if it is a defense, it is a self-defense, the prosecution has to actually come and give evidence that would counter your self-defense. Now, he raised it in his statement. He also raised it in his testimony, even under cross-examination, but nowhere in the decision was that reviewed at all. Now, every single evidence ought to both the Court of Appeal and the trial court. Yes, in fact, even to resolve it and say that, okay, you're trying to retract from your previous statement and we're not going to consider it, it's not credible. At something, anything, no reference whatsoever, but the cross-examination was there. And evidence derived from cross-examination is usually credible evidence because, it's at the adversary cross-examining you, so you don't want to give the evidence. But that was the evidence, and the court did not look at it at all. So if you look at all the decisions that the court relied on, none of it was on all fours with Sunday Jackson at all. So it's problematic.
Interesting. So you do, from your own perspective of this case, you think that, certainly there was no premeditation, it
wasn't proven. At least there was no fact, no evidence that was put forth apart from his confessional statement. And even in his confessional statement, there was no premeditation.
He just said that he killed him.
Yes, he just said he killed him. He didn't say that he intended to kill him. He was angry about it. There was nothing. But we all know that, and it's clear that, okay, there was a wrestling, there was a fight between them. You can't tell me that, in a situation of a wrestling and a fight, then I have the opportunity to run away. When it comes to knife fights, fatality is usually defined the end of it.
And this knife, belongs to this.
Yes, that's one of the conditions. One of the conditions for self-defense is that you must not be the aggressor. And the court even agreed that indeed Jackson Sunday wasn't the aggressor. But then the court went on to say that, however, he could have. That was just the court, delving into the arena. The prosecution didn't even make that argument. It was the court solely on their own or on her own at the time, that who decided that he should have. There was no evidence as to the nature of the farm. There was no evidence as to the nature of the fight, whether he had other means to actually. There was nothing whatsoever. But the court went on and made that decision, and I feel like that's a travesty.
Interesting. I mean, that is the way a lot of the common people, also view it. Including myself. Where both of you and Emmanuel are lawyers. So, Mr. Ogebe, since you went back to the U.S. where you are based, I understand that. The international dimension of this, what is clearly, in our view, a travesty is heightening. So can you update us on that?
Yes, before I do that, I want to commend my learned colleague, Wali Ibrahim, for that fascinating analysis of what transpired in the lower court. In fact, I dare say that if he had been counsel for Sunday Jackson probably would be free today. I just want to, buttress his analysis with 2 quick points. One of them is that the trial judge, Justice Fatima Tafida, claimed in her judgment, in the last page of the judgment, that she had no choice and no option than to sentence him to death. That is fundamentally false. One of the basic powers of a judge is to actually convict a defendant for a lesser charge if it appears to her that that lesser charge has been proven in the courts and that would be an appropriate sentence in the case. So she could have downgraded the charge from culpable murder, culpable homicide punishable with death, to culpable homicide not punishable with death, which is what happened in the Farmer Kinwa case, where the Court of Appeal, as my learned colleague said, reduced the sentence from death and murder to manslaughter and imprisonment. So the trial judge did not know her job. Now, the second thing I wanted to point out is that even in the conviction, the trial judge should have asked for a plea of allocutus, of mercy, to be entered by the defendant and his counsel. And if you look at the trial records, she never did that and just went straight ahead to sentence him to death. Then thirdly, and this is, a key point that he made and which we've been making, is that she created her own facts, which were not in evidence, and gave judgment based on information that she created. So that's very concerning. So coming back to what has happened in the United States, we returned to the U.S. this week after the hearing in Nigeria, or the judgment in Nigeria, and this issue came up in the U.S. Congress. My learned colleague, Nina Shea, a renowned Washington human rights lawyer, brought up the issue of Sunday Jackson, which I had briefed her on, in the hearing before the Africa Subcommittee. And that hearing was to determine sanctions on Nigeria relative to egregious religious persecution and, failure to protect its citizens from persecution of that nature. And of course, the case of Sunday Jackson clearly falls in that category because there are more Nigerians on death row for self-defense against terrorist attacks than there are terrorists on death row in Nigeria for killing thousands of Nigerians. And that is a travesty. A country that cannot protect its citizens from terrorist attacks should not kill the citizen who protected himself from the terrorists that the government could not protect him from. And this is why the case of Sunday Jackson is very problematic. I want to add one quick point here to show you how serious this issue is. A spouse of a Supreme Court justice told me how when they were living in the Northeast, they hired a Fulani man to take care of their cattle. And after the first week, the man came and met the judge's family and said, we nearly had a problem today. The cow entered a farmer's farm and ate his crops. Can you imagine that the man came to challenge me? I almost killed him. This is what a Fulani man told a judge. And so the judge obviously was concerned that, look, this man will go and kill somebody because of my cow. I don't want trouble. And now sacked him from employment, hired another Fulani man. What I'm telling you is an actual fact narrated to me by the justice's family. Do you know that the second Fulani man now stole the cattle of the justice and disappeared? So the family now had to be searching for him up and down. Finally, some Fulani people advised the judge and said, look, if you keep following this man for your cattle, this man might turn around and kill you. So let him go. This is to illustrate to you the extent to which even people in the judicial system have been victims of this phenomenon. And so when you see this kind of case come before the Supreme Court, and nobody could look at it and say, this man did not premeditate this attack. This thing happened to him, unfortunately, and he should not be a double victim of this circumstance. It's unfortunate that he has served 10 years already, which he can never recover. And then after that, you want to put him to death to complete the attempted murder that the Fulani man started against him in 2015, that is unconscionable.
Thank you so much. Last word, Mr. Wali, especially if you can also relate to the issue of the clemency. The attorney to Mr. Jackson, on Friday had said that there's going to be application for clemency. Do you think, that is what the governor ought to do, the governor of Adamawa State, as a lawyer?
Well, before I answer that, I have to say, because I'm constricted to the judgments. I have no idea what happened behind the scene or what didn't happen. And I have to say as well that the policeman who took the statement and the person who countersigned it, another policeman who countersigned, both of them were Christians. And the lead judge at the Court of Appeal is Christian as well. I think that there's enough facts there's enough information from the judgments to actually pursue clemency without, bringing in the religion aspect. But look, that is without prejudice to anybody's motive out there. Regarding the clemency, obviously the governor has the power to pursuant to Section 212 of the Constitution to grant clemency to anybody who has been convicted under the state law. By the Constitution, they ought to have a committee of clemency. If it's a federal offense, it is the president, and I think their own committee is set by the Constitution Council of States, which involves former head of states, former presidents rather, and the president himself. But for the state, it's a state offense, so the governor has the prerogative to decide his clemency team. I don't know if our governors are active in this regard, however. I don't think that, they understand or they appreciate the judicial system to that extent. But indeed, they have the right to either recommit the offense, give a lower sentencing, or or set them free, and some of the conditions are obviously public policy, good conduct, and also a review of the decision itself. And that is what I expect the governor to do, regardless of the pressure, to call in, experts, lawyers in his state, review this decision, let's even see. And if it shows that, and I believe that it is going to show because it is evident that there was a miscarriage of justice, just set them on free.
Exactly. Thank you. Thank you so much, Mr. Ibrahim Wali and Mr. Emmanuel Gibe.